citizenship.
So my name is Mirca, and today I will refute Stephanie's speech. Her speech was the eligibility of Senator Ted Cruz running for president in the 2016 elections. The topic of natural-born citizen has been present in the 2016 presidential election. It is not the first time made prominent, as we've had candidates in the past that fell under investigation when their citizen was tested. Such candidates include John McCain and also our very own President Barack Obama. However, in presidential candidate Ted Cruz's case is slightly different than being born on United States territory. So today I will refute the secondary claims given in the claim of fact speech by Stephanie of the eligibility of Ted Cruz in the 2016 election by examining the meaning of natural-born citizens, which is her first secondary claim. Second, to refute the evidence of Naturalization Act of 1790. And third, challenge the evidence of the eligibility clause under the Constitution. I will begin with natural-born citizen. Natural-born citizen by Clement and Catial. I think that's how you say it. The claim of fact speech stated a quote by Clement and Catial article Natural-Born Citizen. The first Congress established that children born abroad to U.S. citizens were U.S. citizens at birth and explicitly recognized that such children were natural-born citizens. This statement is correct. However, it is incomplete. The accurate statement is as followed. The Naturalization Act of 1790 expanded the class of citizenship at birth to include children born abroad of mother as long as the father had at least been a resident in the United States. The quote was misrepresented and covered the fact that Ted Cruz's father was not a resident of the United States while emphasizing his mother's U.S. citizenship. Additionally, as stated by constitutional law professor of Winter University of Delaware, Mary Bridget McManaman, I can't say that, sorry, Ted Cruz is not eligible to be president. She states, instead, Catial and Clement refer to the brand new British status as part of a long-standing tradition and conclude that the framers followed that law because they would have initially intimately familiar with these statutes. But when one review all the relevant American writing of the early periods, including congressional debates, well-respected treaties, and Supreme Court precedent, it becomes clear that the common law definition was accepted in the United States, not the newfangled British statutory approach. Now that I have explained why this secondary claim did not support the evidence, I will next discuss the Naturalization Act of 1790. Because the Naturalization Act, as stated in my previous point, that the mother and father must be citizens in order for the child, who is Ted Cruz, to also be natural born, it is kind of like a slippery slope because her quote was misrepresented, so it did not show all the facts of how the Naturalization Act applied to Ted Cruz. In the case of Ted Cruz, his mother was from Delaware and his father was from Cuba, but he was residing in Calgary, Alberta, Canada for 3 years, which is also Cruz's birthplace. Therefore, the secondary claim that stated Ted Cruz was a natural-born citizen under the Naturalization Act was false. Now that I have discussed the issue with Naturalization Act, I will next discuss the eligibility clause. The eligibility clause under the Constitution, Article 2, Section 1, Clause 5, no person except a natural-born citizen or citizens of the United States at the time of adoption of this Constitution shall be eligible to the office of President, neither shall any person be eligible to the office who shall not have attained to the age of 35 years and been 14 years a resident with the United States. Okay, so let's review Ted Cruz's eligibility. He is the appropriate age, which is 35. He is 44 right now, so he is eligible for that. He has been in the States for more than 14 years, so he's eligible for that. However, he does not meet the most important requirement of all, the requirement of being a natural-born citizen, as my previous point has stated. The eligibility clause and the Naturalization Act of 1790 does not apply to Ted Cruz. In conclusion, as you can see, the original claims was misinterpreted, thus misinterpreted information about his father's citizenship. Second, the Naturalization Act of 1790 also showed how Ted Cruz did not meet the eligibility to be a natural-born citizen. And lastly, presenting why Cruz does not meet all criteria for becoming a president. Thank you.
Thank you. All right. I thought it got a little bit confusing at the beginning because the term natural-born citizen in that act gets introduced in 3 different places. It's the advocate's claim, there's a preview, and then there's a second preview. So it needs to be simplified a little bit. However, when you get to the body of the speech, everything is pretty straightforward. I think that the context in which the term is used is explained pretty effectively. On the first point, you outline what the term really means. You've given us a kind of historical perspective on it. There's some controversy apparently about how the law is being interpreted, whether it's being interpreted through a common law perspective or through a contemporary British perspective that's going on there. And it sounds to me like the authority that you were quoting suggests that by the standard of the common law, which ought to be applicable here, that this doesn't, that Ted Cruz would be excluded. And you gave an authority on that citation, and I thought that that was pretty good. And then on the second point, again, you signpost what the Naturalization Act is, and then we get some more explanation of that. This is where some things kind of become repetitive. There's this whole explanation about what the law specifies, what the mother being a resident, the father having to have residency for a period of time. I thought that you did explain, for instance, that Ted Cruz's father was from Cuba, living in Canada at the time. The question about whether or not he had ever lived in the United States, either prior to Ted Cruz's birth or after Ted Cruz's birth, I think that might be a relevant issue. It doesn't get discussed here, so.
And I had one.
Yeah. Like I said, it's probably something that would add to the argument one way or the other. I thought you had a tough argument going on here because this is really one of those things that I think. Legal people are you're operating in the minutia of, arcane laws and definitions, and I'm not sure that any court would ever rule in the positions that Ted Cruz is not eligible for this. So you're taking that position. I think you could also argue that there might be problems with this. Instead of having to take the opposite position that he is eligible, you could simply argue that there's enough ambiguity here that it creates a problem for us. If we decide to support Cruz, we ought to recognize that a problem exists, that there's going to have to be some discussion of this outwardly. You don't have to necessarily take the position that he's not eligible, but you could simply say, you know what, we haven't run into this situation frequently in the past. The only example that we have is you mentioned John McCain and Barack Obama, and Obama clearly fits the one definition in the mother being a citizen, that sort of thing. And then and McCain, his situation was it's on a territory, so that But other than that, everybody else that's ever run, we haven't had to worry about this thing. And this is a situation where we have to worry about it because it's come up and because we had those issues with Obama and McCain before. We have to think about that and say, so we don't want to dismiss this issue out of hand. I think that's maybe the way you want to present this as an argument. Instead of trying to take the opposite position and win it without having a legal scholarship in the background, it makes it a little bit tough. I thought you did a very credible job, though, in presenting those arguments. All right, thank you.